examples of possible beneficial effects. Unfortunately, from my point of view, the whole idea of adverse possession of property was upheld by the European Court of Human Rights. They permitted it, whereas I don't think they should have done in a case called J.A. Pye against the United Kingdom. In other cases, the court has shown much greater protection for workers who are being dismissed for what they get up to in their private lives. Mr. Pay nearly won his case, though he lost it because he was a difficult chap. But his case, he was dismissed because he went to sadomasochistic clubs at weekends and dressed up wearing black leather outfits. He lost his job. And another case where I think beneficial results might take place would be in cases like Hunter and Canary Wharf, where indeed the minority judge in that case said there was a human rights issue at stake. The human rights issue here was you may not see it as a human rights issue. This is Canary Wharf in London. These buildings are very high. People living in these little roads here and there couldn't get television reception. Fundamental right. Absolutely. No, it is. It's a fundamental right to get your television. I think the House of Lords said, no right. You've got no tort claim. You've got no tort claim. There's no law of nuisance or anything like that which can help you. But it seems to me that tort needs to be reformed so that people do have a right to get their television. And indeed, in a German case, that's exactly what happened. A Turkish person was entitled to get reception of television news in Turkish. Finally, last slide. So I've argued that constitutionalisation will have, I think, some beneficial effects. The law will be tweaked, little gentle changes, I think, that will be beneficial because they will recognise the value and interests of particular individuals. The real worry, I think, about constitutionalisation is this worry that somehow the courts will be deviating from following the law. The traditional rule of law idea that what the judges should do is just follow the rules that have been laid down, not think too hard, apply the rules and get the result. But that view of the rule of law I've never found very attractive, that formalistic black letter approach where you just say what you have to do is follow the rules. That is a version of the rule of law. It's a very valuable version of the rule of law. Life is terrible when governments and big business ignore the rules. But I don't think it's all of the rule of law, and I agree with Ronald Dworkin, a famous Oxford legal philosopher, who said that the rule of law means more than that. That sometimes when the law is unclear or ambiguous or seems controversial, at that point judges should not apply the rules laid down, because often the rules will be unclear, but to think about the fundamental rights that people have, the moral and political rights that people have, on which the legal system is based. And that version of the rule of law, which says that ultimately the rule of law is there to protect people's rights, not just enforce the rules, although enforcing the rules is very important, that view of the rule of law, protecting people's rights, seems to be the best view of the rule of law, and one which is implemented by the constitutionalisation of private law. So, for me, therefore, constitutionalisation of private law, the application of fundamental rights to private law, is a good thing because it implements this more sophisticated version of the rule of law. Thank you very much.
Let's start the Q&A session.